cheers.
Virtual
We normally
cheers.
clink.
We clink, but we're too tired to get water tonight.
Can I get permission
To what?
that, like, on some future episode, we're gonna have a really cool whiskey. We're just right now trying to stay.
It's dry
We're just
January.
we're trying to stay alive. There is so many trials back to back to back.
Yeah.
It's like it's a really heavy spring.
It's a tornado, as I told Nick.
You know, we kind of spoke a little bit about what it is, and I want to say this now because there's been 2 or 3 calls this week, and we'll talk about that one case where we had a withdrawal just before the Christmas break, or the winter break, or the Hanukkah break, whatever you want to call it, or the Kwanzaa break, or whatever.
There's a few more.
There's a bunch more. Just name them all.
That's okay. I forget.
And again, it's amazing how this happens. So people call in and they're trying to change counsel, and I'm always trying to ask, who's your counsel? Do they know you're changing counsel? Have you sat down and spoke to them? Have you discussed the case with them? And the same thing keeps coming out of at least 4 of these intakes I did in the last week, where they go, well, I don't see why this would be a lot of work.
Yeah.
Because they haven't produced any video, they haven't produced any evidence other than her complaint and some text messages. And I was so frustrated with one client, I literally hung up after a while. One intake. And I don't know how to try and get it across over and over that in Canada, as well as other jurisdictions around the world, a statement of a complainant is sufficient to give reasonable grounds for the police to lay a charge, for a case to be prosecuted upon, and a person to be convicted on. Right. Especially if at trial, the accused doesn't testify.
Especially.
Right? And we've seen that in cases we've taken over for appeal. There does not need to be corroborating evidence under the criminal code. That's been abrogated a long time ago. So, and there's reasons for that, good reasons for that. So any complainant of abuse can come forward and a case can be found beyond a reasonable doubt on the person's evidence. So, if anybody wants to watch this who's a potential client or looking for a lawyer, whether it's our firm or somebody else, yes, it's completely sufficient that the police just take a statement, and they may have some text messages, frankly, given over by the complainant that can support her position, and that's sufficient.
And that's evidence. They don't understand.
That is evidence.
That equals evidence.
And once the person testifies in court, that can be very compelling evidence. So be careful. Don't assume it's not going to take a lot of work or it's not going to be a difficult case, because I haven't had a sexual assault case in my 31 years that wasn't challenging. So I just had to start off with that again, because I was hoping that as more and more information gets out there, lawyers would be explaining to clients, and I'm pretty sure a couple of these guys, because I wasn't very supportive of them changing counsel, I said, you've got to sit down, speak to your lawyer, and understand why he or she says it's going to go to trial. So let's talk about for a moment a brief case study on a file that we finished just before the winter break. Nick, you came on that file. There was some complex statements. Tell us a little bit about the case. What were the charges? And then, what was the complexity of the statements? And then we'll talk more about it.
So it was a historical allegations of historical sexual abuse. The complainant, who was an adult, alleged that her cousin had begun sexually abusing her when both she and he were children. There were a lot of family get-togethers and sleepovers at which he would do this.
Allegedly.
And then there was a period of several years where the abuse stopped, according to the complainant, and then resumed again when he was an adult and she was still a child but almost an adult. And I think by the final allegation, both of them were adults. And so, sort of right from the get-go, it was difficult in terms of reading her police statement and working out what she was actually alleging, because she even admitted, quite frankly, her memory wasn't good, and so she certainly didn't recount events in any kind of linear way. And I think my first task on that case was to go through her statement with a fine-tooth comb and then build this, what turned out to be quite an elaborate color-coded chart with various sort of dates of references and ages and so on, and work out exactly what she had alleged. And it wasn't just us who had had difficulty with that, because it was clear from the information and disclosure that the police and the detectives had really had difficulty working out what allegations happened when. And so even I think right up until trial, we were revisiting the original statement to try and work out very precisely what she was alleging, where it happened, and then she made two subsequent statements,
Correct,
much briefer, where she updated some of the earlier allegations, added some new ones, but it wasn't quite clear whether the new ones were new or whether they were duplications, so on.
Are you getting nauseous listening to this?
Yes.
It was very,
I am.
Yeah, no.
very difficult. And what struck me reading that was how are you prosecuting somebody when it's not even clear what's
happened. Yeah.
And let's just, so the person was charged, the police had charged him as a youth because a number of these offenses occurred when he was a youth. So there was a court information with multiple counts of sexual assault, sexual interference, and then an adult information with multiple counts of sexual assault and sexual interference. So there were two. The Crown decided not to proceed on the youth charges. We'll talk about it later. There was something called a similar act application that we fought, and if it had gone through, we would have won. But there was multiple counts spanning almost a decade. And what you're expressing right now is because both the police and us as the defense, and your chart was very elaborate with lots of color coding, because we had to try and create a timeline. Because in historical cases, they're challenging enough because there is some leniency given, of course, to a complainant because they're not going to get dates or frequency as accurately, especially if you go back a decade or 2 decades. Can you imagine going back 3 or 4 decades? But also because she was young at the time, as being an alleged victim of this, that the case law specifically says that there is a lot of leniency given to the evidence of a complainant of a young age, where they're not giving evidence in a linear way, where there is difficulty with the frequency or the description of the timing or exactly what happened. There's a lot of leniency given. We've talked about this on a number of episodes, but I would keep coming back to it because these are so challenging. So you get all this leniency that you give to a complainant. It doesn't lower the threshold of proof beyond a reasonable doubt. But it's very hard to get at inconsistencies when there is such latitude given to such vagueness. So tell us a little bit more, because it took quite a while, because I had read through it and then I asked you to do this sort of timeline because we needed to prepare the defense narrative. We'll go to that next, but when you go back to the 2 additional statements she provided, you raised a really good point there. Who knew if there were new allegations?
Yeah.
You couldn't tell.
Right. Yeah, and another thing that was very difficult, you couldn't tell because often the locations would be the same, and she would describe essentially what she described in a previous statement, but the timing perhaps was a bit different, and she claimed it was a new allegation. I think she obviously didn't know, and she probably didn't remember exactly what she'd said.
Because she was lying.
The original statement anyway. And so it's, it was very difficult sort of understanding, is it new? There were just a lot of question marks, even when he did disentangle everything. One thing I noticed as well, I think the police, again, had difficulties separating them out too. It wasn't just us. I mean, even reading the transcripts, you saw this detective saying, could you just clarify this and that there? Or I'm just going to come out of the room and then go back into the room. And then I had problems even looking at the information with all the adult allegations with the dates, and they used such a broad spectrum of dates that it was hard actually matching up each charge to a factual description in the statement.
Sounds like a nightmare.
It's a nightmare. So just think about it, and Michael, just jump in for a moment. But because you've done a number of these cases as well, where it's a child complainant, it's a family-related allegation, we have to go through this very in-depth breakdown of this evidence so that we can actually try and interview the client and get from the client some sort of timeline in some way to refute the allegation.
And to prepare our cross-examinations. Like, how do you...
But even to do that, we need the defense.
Of
like
course.
We call it the client's chronology, right? So what we do is, I think we've mentioned this before, once we give the client the disclosure and they've had the opportunity to review this statement in detail, we want them to give a chronology. That's a document just for us. It's solicitor-client privilege. But we want a complete history. And then we want their sort of rebuttal. But many times they're not able to give that. And in this case, how do you even figure it out if we can't
If we can't figure it out.
if we can't figure out a timeline?
Right. No, it's very difficult for these clients. So sometimes they have to spend more time with the disclosure. Other times we'll review it together with them. Sometimes we'll get other family members involved to see whether we can pin down any points in history or points in time. Because I think you interviewed a number of witnesses in this case, right?
Yes.
That's exactly what we did.
Yeah.
Several times over.
And were they helpful in trying to...
Yes, I mean, it's difficult because I think the witnesses in that case, or in any case, will be extremely keen to try and give as much detail as possible that they imagine will be of benefit to us. So it's almost kind of there's a vast amount of information coming at you, and then so it was useful ultimately, but a lot of it was kind of siphoning it out and trying to explain, no, this isn't going to be relevant, this is going to be more helpful. But it does help sort of doing that discussion, because especially in that case there were multiple locations, so just working out where everybody lived.
Right, and these were all at family events or family locations, right?
Yeah, that's right, they were. And also sort of getting...
And trips.
And trips.
Yeah.
Well, you're lucky then that you had the family unit able to assist, right? Sometimes you don't have that.
No, but I'm sorry to interrupt, but what was, and I appreciate it was frustrating for the police, but they only interviewed the parents, and the parents of the complainant actually were the ones who came across. They were like, we're completely shocked. No clue. No clue. And all they could confirm was, yeah, we had a lot of get-togethers.
Yeah.
That's all they could do. Yet there was other people that could have been interviewed. So we interviewed, and Nick interviewed a number of times, a cousin, and then the cousin's parents. Although they weren't ultimately helpful to have as potential witnesses, it did help us in understanding where things are alleged to have happened, what the dynamic was, who would have been around, what sleeping arrangements were, what was the rules in the house. Like, so for example, some of the allegations were at nighttime, the only female cousin would sleep in a room with 3 other male cousins. And while in that room, allegedly, some of the allegations was our client had committed a pretty brazen sexual assault, which anybody else would have woken up and heard if that were. This is why I'm saying it's not true.
Right.
One of those allegations, we're not going to talk in great detail about it, but Nick, you were like, what the f***? You got to swear more because it's
Right.
the podcast, right? But like, you were like, what the f***?
Yeah, I need the whiskey before I start swearing.
It's coming.
It's coming.
Yeah, no, I was very surprised. I think that was one of the allegations that was updated. It was also the earliest. It was odd because it was the earliest allegation, and yet had by far the most factual detail attached to it.
And then allegedly from there, 10 years after, it would de-escalate.
Yeah. So the other allegations, sort of de-escalated from that. But then she updated it in a subsequent statement. But even there, her whole update, in which it became even worse, was she even said outright, "Oh, I don't remember this, but I've just worked it out." And so it wasn't
right.
There was sort of lots of language that I think we were planning to use for cross-examination.
Yes. Memory was a big area I was going to go over, because I was of the view that if this was fabricated, and it was fabricated for all sorts of selfish reasons, and maybe feeling jilted by the cousin who basically went on with his life and wasn't as close anymore. But yeah, there was memory issues that I wanted to play up on, because there was language that was being used was like, well, I don't really have a memory of it, but I worked this out because this is how it must have happened.
Oh, God, that reminds me of Courage to Heal from the 80s and 90s. Remember that book?
Yeah.
The opening line in that book. It's a self-help book.
Yeah,
it was like, if you feel like it happened, then it probably did.
Okay.
No, but that's a really important point.
It's terrifying.
That's an important point, because that's at the nub of what we've been doing a lot of work on, which is this recovered memory, or lost memory, repressed memory, whatever, which is utter crap.
Yeah. Scientifically
But
shown.
that statement of self-healing. Say that again.
If it feels like something happened to you, then it probably did.
She was saying that. I felt that I was sexually assaulted. There was an aspect of it where she goes, it had to have been intercourse.
Had to have been.
Because I felt afterward it had to have been intercourse, but I don't actually have a memory of it.
Right. That's terrifying.
I mean, yeah, she did, and those were in the latter statements too. That came about I think over a year after
Later.
the first one. Yeah, I don't know what happened in the interim to sort of make her change her mind there or update it, but it was.
I don't think the family rallied around her the way she thought they would.
Right.
I think she was looking for more attention. And I know there's a bunch of people who would like love to just rip my guts out for saying that, but this was an attention grab.
That happens.
But let's go back to that. So one of these allegations, there's 3 cousins in the room, all of like sufficient age to be able to look, hear, and understand, right? And this one would have involved a tremendous amount of movement and active sexual abuse, okay? So nobody's interviewed from that room. Nick had a number of meetings with a cousin and with our client's brother and with our client's family. I met with them and we went over and over and over. And eventually it was really helpful because once we got that breakdown, like 100 hours later of work, okay? Like we gave a massive discount on this because it was a lot of work. But then we were able to say, okay, so we pretty sure this allegedly occurred during some sort of event at maybe this year. What were the sleeping arrangements? And it's like, well, the 2 brothers, so the accused and his brother, they had their own room. The cousins they'd sleep in a separate room. And we had an open door policy. When the kids went to bed, we didn't want them shutting the door and running in and out of rooms. And we had a very strict upbringing. Like, this is the way it is. So finally, we were able to start building a defense narrative because we were able to get some structure to the allegations, and then we were able to try and look at periods of time. What was the house rules? Who was present? University, right? So some of the allegation occurred during a period of time when our client wasn't here.
Yes, yeah, they did when we worked out the timeline, and then it was kind of a bit of a eureka moment when I sat with the client and they're saying, no, I wasn't actually there at this point, so I wouldn't really have been at the house because I was in a different city, so that was good to know. Yeah. And then, I mean...
Yeah, good to know.
It's an important point.
Yeah.
So I think another thing was a lot of the adult allegations had concerned sleepovers as well, and the cousins were unanimous, like, well, we didn't have sleepovers as cousins because as adults because we were adults.
Right.
We weren't all crashing around playing Nintendo in our sleeping bags age 25. Like, it didn't
mesh.
So it didn't. There was a lot that we kind of like, yeah, this doesn't make sense. And I think we kind of gradually built. Yeah, and it was each of them sort of confirming independently as well. We kind of got them interviewed separately, and so it was. Yeah, I think we're getting a pretty strong case. I mean, it was withdrawn, which was the best outcome, but
yeah,
of course.
But this is a great case study because it's how you have to start with one of these amorphous, long, convoluted word salad statements, try and deconstruct it and make it into some sort of a structured timeline, intelligible thing that you can actually try and analyze it. Can you imagine trying to defend that if you're not able to put some structure on it? Because with the way some of the law is, it's very easy to still get convicted. Because I had a judge. We have a judgment coming up soon where a judge, he just denied it. Well, what the is he supposed to say?
Yeah,
I had sex with my daughter. There was consent. Of course it's a denial. But when you look at these other factors. But the case law troubles me so much with these family-related ones where it could be a cousin or it could be within a high-conflict divorce that, plausibility, whether it's plausible that happened, is not so much a viable argument for the defense. Talk about that a little bit. People, we need to understand this because when you look at the research in the case law, it's amazing how highly improbable or implausible the allegation is, doesn't seem to have much traction with courts.
No, it's bizarre.
Because although you can't presume somebody who would be a would-be sex offender would automatically take that extreme risk, it's almost a given, even though they say we can't assume that.
It's almost like a reverse onus.
But the plausibility cases, like...
Yeah, no, I agree with you 100%. It's like, well, like you said, it's frustrating because it's...
So, like, there are so many cases of convictions where there are pretty good arguments of implausibility.
Right.
And they're just blown out of the water because, well, no, I mean, you can't assume that somebody wouldn't do that.
Yeah, I don't get that.
And in our case, a lot of it was about plausibility and about it couldn't have happened. But at least we had anchors in time as to why. One of those big anchors was our client was away in university.
He wasn't present.
A 5.5-hour drive from Toronto, where he was grinding at university in a very challenging science-based undergraduate degree to go to medical school. And he only came back for the major, like for the holiday time, or if there was maybe a reading week. That was it. And all of the cousins were unanimous in saying, as adults, it's like you said, like at 2019, 2021, like we weren't sitting around in our pajamas playing Nintendo.
Yeah, but it took a lot of work to get those anchors. That's the thing.
A lot of work. And when you think about it, the police could have interviewed some of these cousins. And the cousins would have said, like they did to us, we never had sleep. Like I had a girlfriend, he had a girlfriend. Right. The girlfriend used to come all the time. Like we didn't have sleepovers.
Right.
Amazing, eh? So what happened? Well, we get ready. Client is prepared. We have 2 or 3 witnesses we're calling in addition to the client. Cross-examination has been developed. Took us about 50 to 60 hours to draft that cross. And this is again, while I say no case is simple. This was over a 300 hour case, and we hadn't even gotten to trial.
We did a similar act application too.
Talk about that for a moment.
So the Crown
explain what it is to everybody. We've spoken about it before, but basic criminal law 101.
So similar act evidence. The Crown was seeking to admit evidence of similar acts, sort of committed in the past, to demonstrate a specific, or in this case, a situation-specific propensity to commit the allegations. So in this case, Joseph mentioned there were some allegations that occurred when both the accused and the complainant were children, and then the accused became an adult, and the police or the Crown was only prosecuting for the adult allegations. The Crown wanted to admit facts about the childhood allegations in order to support their position with respect to the adult allegations. That's sort of simply, that would be it.
Right.
And then they submitted their application. They said it showed there was a situation-specific propensity that the accused would abuse the complainant whenever he had the chance to at family events when they were alone, and therefore these should be admitted. And then my job was to write the response, and the response was essentially to focus on the time lapse between the two alleged periods of abuse. And case law is pretty clear when you have allegations that are happening as children, the kinds of motives that would lead somebody to abuse a child, to abuse another child, don't really translate well into adulthood. That was the basis of our response.
What was one of the most helpful cases?
There was one that was very similar, and the judge was clear, saying, no, you a child who abuses another child, then you grow up, you have sexual maturity, it's a crucial stage of development, you're a completely different person. The reasons for why an adult would abuse someone are too distinct for these really to speak to each other. So that was the thrust of the application. We didn't end up submitting it because everything...
Well, we filed it, we didn't argue it.
Okay, right.
Yeah, we filed it. We filed the response. It was a very robust response. It was very well written, Nick.
Thank you.
Thank you. Yes.
No, it was very good. And this is another example of why we had Diana was on this file to a certain extent as well, and then Yuvica had worked on it. Like we often have to have many eyes on a file in order to try and get a good comprehensive defense. But that was a very solid response to their application. We would have won it. So we get there for trial.
Yes. Yeah, and it was everyone was nervous.
We're set up for a 5-day trial.
Yeah.
Terrifying. But that's what we do.
That's what we do. It's fine. And his client was very nervous. The family was there. Everyone was there. And I start to have discussions with the Crown attorney. And guess what? The complainant doesn't want to be cross-examined.
Imagine. Maybe she saw the chart.
She saw nothing,
I know.
But the complainant did not want to be cross-examined. When it came down to it, it was complete, like, I don't want to be cross-examined.
Just like that. I've put this man through hell, and I don't want to play today.
Was there a family aspect to it as well?
We don't know, and we had I think a very reasonable-minded Crown attorney who's been a Crown for over 30 years, who I think has an intuitive sense of cases, and felt that there might have been some family
Pressure
input.
or something?
Well, no, I don't think pressure. I think it was like, I think there was some family realization that couldn't have happened.
Okay.
Because of a number of real factors. Right. And I think also it was pretty clear through the family that there was a robust defense. Let's just put it that way. That there was a very serious law firm on it.
Right.
And I think certain other family members who weren't directly involved were saying, how could that have ever happened? For many of the because once we started, you cannot underestimate how people will talk in a family. So we started interviewing various family members, and in some, culturally, the families still remain very close. They talk a lot.
Sure.
And once we're interviewing them, word will get around like, well, hold on.
Yeah.
I know they didn't tell us what the evidence really was, but they asked us about these time periods, and it happened during a sleepover. We never had sleepovers from this period onward. So that had to have gotten around.
For sure.
And when the complainant was adamant about not wanting to testify, the Crown was like, I'm not of the habit to push any complainant to testify against their will. Good for her.
Yeah.
Good for her. And I think she had a bit of an intuitive sense that this was not maybe a legitimate case for them to prosecute. I had some very good discussions, which I can't talk about because they're privileged. But it's a perfect example of what we do throughout all of our now 101 podcasts or 102 podcasts. We talk about situations where constantly we're under this pressure from all sorts of noise outside, that there's no such thing as a false allegation.
Right.
That in fact, if there are, it's very rare. And now it's becoming more of a cottage industry that you're seeing personal injury firms advertising sexual abuse cases that they want to bring lawsuits on. And this is another one. This is another perfect example of where, when you looked really deep at some of the allegations, it's like, no, that could not have happened without these people waking up, without them knowing, without somebody running to a parent, given their age and everything else. And just how maybe other family members finally woke up and said, this is not right. There's no way, from what we glean, this couldn't be right. We can't do this to this young man. Imagine the dangers if that didn't happen, right?
Oh, yeah.
And we see it all too often. But that's why we do what we do.
It is.
So was that like satisfying when I come out from the Crown's office, everybody's sitting out there?
Yeah, the family were very emotional. I mean, I could sort of tell by your stride. I was like, something. Because I must say though, I was actually very surprised when it was resolved via a peace bond. Or then, on reflection, perhaps not, because I did kind of help wonder about the complainant. Was there like a hope to sort of reconcile, or was a more kind of restorative approach? But anyway, you came out and I could see it was good news, and then you told the family, and they were absolutely sort of delighted. And I think his mother was in tears, and sort of aunts and uncles were there as well. And it was, and I just thought, my God, sort of took a massive relief to have this.
Yeah, this is a young man who has finished his education, who's on, the beginning of what will be a successful career, and his entire life could have been flushed down a toilet with a conviction. utterly flushed down the toilet. And he said, my life has been in suspension for 2 years.
That's rough.
I always think of it, even as soon as a complainant goes to police, because it's almost guaranteed to go to trial, like what often
It is, yeah.
And you think, well, it's almost like punitive damages. That is several years of somebody's life
And money.
And money.
It's tens of thousands of.
I mean, had it been actually what our actual time was, this bill would have been over 120, 130,000. It was a lot of time. But, so that was withdrawn. So all charges were withdrawn. Client signed a peace bond simply just to make it go away, which was there's no civil or criminal liability. There's no attachment of any admission. There's nothing. They're innocent. And it reminds me a little bit of another one we spoke about previously, which when we finally got a witness who was, at the time that allegedly sex assault is happening to this other girl, finally was forced through us having a private investigator going after her finally, and happened to work for the Attorney General's office. So I think they figured, I better come forward and tell the truth. Told the truth, and it completely undermined the complainant's evidence. I mean, it completely undermined it. And in fact, in that case, we've spoken about this before, but so much of these are back to back. The sister of the complainant was actually giving a play-by-play that undermined the evidence of the complainant. And then there was one person, these two girls go to our client's house. One of them says she was sexually assaulted. The other girl is not interviewed, doesn't want to be interviewed. We go after with a private investigator to try and hunt her down because we need that evidence. Finally, she decides to go to the police to give an interview. And the interview undermines the complainant's narrative. So how do you explain that? All those people who just all over me on Twitter that sexual assault allegations are never fabricated, that I am doing something incredibly harmful by spreading the myth that there are false allegations. How does that? You're welcome to come to my office and read the statements, read the cross-examinations, and then you tell me if this was within 1 month. One was withdrawn in November.
Right.
I think it was November 30th, and then this one was withdrawn December 17th.
Yeah, very recent.
Okay, so that's within less than a month. 2 big important cases withdrawn. One clearly because evidence has undermined the complainant. Another one where it's pretty clear the complainant did not tell the truth, did not want to face the music at the end and be under the pressure of cross-examination, and where other independent witnesses within the family were confirming the fact that it could not have happened because we were never together at these times. And for a 24-month period of time, the individual, our client, was not in the city, except for 2 weeks at Christmas time or the winter break, and a couple of reading weeks, and that's it. So how do you square that away? And that's just 2 cases.
Tip of the iceberg. We have so many.
That's just 2. I'm getting another one withdrawn now, probably, where fortunately the complainant has retained counsel. It's utter bullshit. And God bless the Crown Attorney. So I always check in case it's one of the offspring has done something. Okay, no, it's okay.
No one's in custody.
No one's in custody. Family's good and safe.
Good.
God, this is going to be a bit of a long one. So, are we okay for time? Okay, so just
doesn't matter.
Just 4 more minutes.
Just do it, Joe.
Okay, so 2-year relationship, breakup, not good. They had an apartment together. I think they bought a property together because for investment they thought they were going to get married. Bad breakup. 4 counts of sex assault, beating, choking, as much sections under the criminal code as you can find for abuse, okay? Pressure is building. Complainant goes to retain criminal counsel. Probably because they gave fabricated evidence. I got access to the statement. I still don't have it in my possession, but I was able to view it through a shared Zoom meeting I did. It's a 3.5-hour body cam video. This is the latest debacle that's happening. So because of the pressure and the resources on the police, and I'm not blaming the police for this, because they just had $12.5 million ripped right out of their budget. So when we complain about their investigations, I'm mindful of the fact that they don't have the resources they need. I am mindful to that. So these were uniform officers who are on scene doing their best, turns on their body cameras, and they're taking the statement. They're taking the statement of the complainant whose friend is there, and the friend is talking, and the complainant's... It's 3.5 hours, and it's garbage. And in it is the complainant is talking and complaining about this property that was leased, and I'm money, and I'm going to get f***ed over, and money, and f***ed over. And it's like, where's the sex assault and the beatings you're talking about? It's 3.5 hours. The Crown doesn't even want me to transcribe it right now because it's such a disaster. And I'm not blaming, again, the officers who are on scene, because what would have happened normally is after that's done, the complainant would then attend the police station and give a proper statement with, officers from the sexual assault, unit with proper cautions.
Yeah.
But I think the complainant figured out pretty early there's going to be a lot of pressure right now because there's a civil action going on behind the scenes here. And when I got to view various portions of this statement, I was like, in the Crown, so it doesn't smell right. That's 3 now that I've been dealing with, and with like just
60 days.
Where I'm fairly certain we're going to get it withdrawn, because to prosecute that would be wrong. But that's 3 in 60 days. Now, look, one of the cases we've had for 2 years, but when this is why I say, when you look at our caseload and how many are withdrawn or we win at the end of the day and are able to establish fairly convincingly through cross-examination that the allegations are not truthful, that they don't even come close to beyond a reasonable doubt or even a balance of probability. Statistically significant anecdotal evidence for us that we have too many of these cases that come out as false. Now, again, it may be because our practice attracts people who have really good feelings about the fact that they're falsely accused. We have a very sort of niche practice where people seek us out and do come. They come out of high conflict divorces, bad breakups. There's all sorts of ulterior motives in these cases. But it is significant because you've seen it now. You're going through many of these statements, and the bulb is going off. It's not a myth.
No.
And over the next, this year for our, I know a lot of the reviewers want us to do more of these case reviews. These are 3 perfect ones. If this one is withdrawn, I was so shocked at the body cam footage in the statement. I want to review that if it doesn't go to trial and it's withdrawn, because there's just certain aspects of it where it just screams out bullshit, motive to lie.
Right.
Do you have any upcoming right now to add to my statistics at the moment?
Very soon, yeah. Remember, we have that case where coincidentally she's had another ex-boyfriend charged back to back with the new charge.
And we talk about that, and then we're going to shut it down. But talk about that for a moment, and we can't even cross-examine on that.
We can't touch that, so I have...
Lay this out like in a pause. Lay it out simply for everybody.
A sex assault case going to trial in a few days, few weeks. He says, she says, ex-boyfriend, girlfriend type of scenario. So as we're preparing for that case, we get a new intake. And
imagine this.
Yeah, I'm looking at the guy. He has the disclosure. He's gotten some of his paperwork from the Crown, and I'm looking at it going, that name sounds familiar. And that father of the complainant's name sounds familiar in the statement. And then I put one in, Amy, who's photocopying this at the same time.
Our senior law clerk.
Our senior law clerk also goes, holy shit. You can bleep that. She goes,
no, don't. I want you to swear.
That. It's like, what is going on here? So we find out she has the initial relationship with the new intake. They break up. She's pissed. He ends up getting charged with sex assault. Goes to a house party almost less than a month later and has this new guy charged with sex assault. Back-to-back sex assault. I cannot...
And something very distinctively similar in the way she complains about it.
Yes, her language, how she complains about the incident, didn't want to use a condom. Like, it's almost like she's running a script.
Right.
I cannot, under our current law, cross-examine her on that. Your jaw's supposed to drop at this. I cannot cross-examine her that she has made this prior complaint, and in this second trial that I'm running.
The law actually says, unless you can establish that the other allegation is demonstrably false, which essentially means in the case law that she recanted, it is inadmissible under Section 276 and inadmissible because it's not relevant. So it's other sexual activity and it's not relevant. So how's it not relevant?
Can you imagine?
So we faced that similar act application, right? Talk about a reverse similar act application, okay? So when you take the allegations, and it's not broken down yet because they're both, one's going to trial but the other one isn't yet. So you'll have to look at the statements, but there are very distinct similarities in what she's claiming as a sexual assault. Not wanting to use a condom, something else. They're strikingly similar. Shame we can't bring a similar act application to say that this person is a serial fabricator.
Right.
Can't do it.
Nope.
But, what do you think? What do you think? Are we wrong? Maybe we're wrong. Maybe it's just bad luck.
Bad luck for her, yeah.
And it could be. But when there's such striking similarity in the nature of the allegation, the unfolding of it, and the language,
it's dangerous.
It smells really bad.
It smells really bad. So I'm trying to figure out how to sneak it in anyway.
Well, maybe we need, that's an old case, maybe we need to, just take a shot at it. And, if you win, we won't be able to go to appeal on it. But, it's something we have to take a shot at to see if we can reopen again.
Right. And I may explain to the judge, I'm not so interested in the sexual activity. I'm not going there. It's the fact that the allegations made, right? And the fact that the language being used, right? That is critical. It's almost
unfortunately, because of the language, you're going to have to get into the sexual act.
I know.
That's what we face as a real problem. But there's something about it in this case
it doesn't
which is
sit
very,
well.
very awkward. And it's funny. It's it wound up in our office, both those cases.
Right, which is in and of itself something. But yeah.
But and you're finishing off that other case where it's the sexual exploitation one where we're expecting victory.
Right.
At the end of this year, and we've spoken to somebody, we're trying to get this academic to come in and do a case study of a lot of our transcripts and then compare with other cases as well so that we can start to have some sort of a more a proper study done on wrongful accusations. So we're trying, because nobody else really wants to do it. No, our government's not remotely interested, and of course there's no organization out there who's interested. So we're going to try and see if we can get some funding for this and get this academic in to do it. But I'm just staggered by, that case that we had out just before the break that we got to withdraw was extremely satisfying, and how we broke it down. But it always comes back to our theme that it's not a myth that there are false allegations.
No, absolutely not.
And I don't know why it's so hard to just say, yep, some people lie. Male or female, it just happens.
Yeah, imagine.
Well, good night, guys. Thank you.
Nick, pillow?
Yes, thank you.
Pillow
Thank you,
talk
everybody, for... Where's my pillow?
Use pillows
Well, you
here.
can do it.
All right, I try not to look at it this time.
Try to memorize it now.
Don't forget to like, comment, subscribe, and share.
No,
And thank you
put
again.
some life into it.
I'm gonna get Tyler back down.
Tyler, yeah, he's got the voice. You're
Don't forget to like, comment, subscribe,
See?
and share. And
That's
we'll
how
be
it's
back
done.
with you next week with our next podcast.
See, that was mellifluous, that word I used earlier.
Good night, everybody. And
Good
thank you
night.
very much for viewing and all your great questions. Good night.